All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
I trust that the connection is established now and we can continue then.
Good afternoon, Your Honor. Thank you. The connection is now okay, so Maître Yarefal will proceed with his observations. Thank you very much.
Oui, bonjour, Monsieur le Président. Bonjour, Monsieur le Juge.
Maître Fall, good afternoon, Your Honors.
Mes collègues m'ont chargé de vous entretenir
My colleagues
de la victimisation
asked
de la
me
diaspora
to
dans
speak
cette
to
affaire.
you about the victimization of the diaspora
Si nous mettons
in
de
this
côté
case.
la conception
If we
historique
set
de cette
aside
notion de
the
diaspora,
historical connotation
nous pouvons
of
retenir que ce
that
terme désigne
word
de nos jours
diaspora, we can
la
understand
dispersion d'une
that the
communauté à travers
word
le monde,
means today
en tout
the
cas, la
dispersion
population
of
est
a
ainsi
community
dispersée.
throughout the world, or the dispersed
Dans
community
cette cause
as
qui nous
an
réunit,
entity.
il y a
In this
effectivement
case,
une diaspora.
that brings us together, there is indeed a
Selon les
diaspora
informations les plus partagées,
based on the most
et
widely
on a cessé de le
circulated
répéter depuis ce matin,
information, and this
une
has
attaque
been
systématique
repeated
a été dirigée
several
contre les
times this
populations
morning.
musulmanes
A systematic
au
attack
cours
was
des événements qui se
directed
sont déroulés
against the
en République
Muslim
centrafricaine.
populations in the course of the
Les
events
massacres
that
qui s'en sont
occurred
suivis
in
ont
the
été d'une
Central
violence telle
African
que la situation a été
Republic.
parfois
The
décrite
massacres that ensued
comme
were
pré-génocidaire
of such a
et a
degree
entraîné
that
un
some
exode
people
massif des civils vers
described
les
them
pays
as
voisins.
pre-genocidal and led to massive
Les sources
exodus of
concordantes ont fait
civilians
état de
to
plus de
neighboring
600 000
countries.
réfugiés
Many reliable sources
qui
indicate
constituent à
that
ce
there
jour
are
ce que nous
more than
avons tantôt qualifié
600,000
de
refugees
diaspora.
who today make up what we have been
600 000
referring
est
to
un chiffre
as the
effectivement énorme.
diaspora. 600,000 is an
Mais en
astronomical
revanche,
figure,
dans les statistiques que nous
and
détenons,
yet, in the statistics at
seules
our
quelques centaines d'entre
disposal,
eux ont été
only a
autorisés à
few
participer à la
hundred
procédure.
people amongst them were authorized to
Face à ce
participate
constat
in the
et au risque
proceedings.
peut-être de paraître
Given this situation and at the risk of sounding obsolete, we still have to take into account the important progress that has been made ever since the Rome Conference and the Kampala Conference. But I have no choice but to reiterate the heartfelt appeal of the NGOs to the decision makers. They said, punishing criminals is of course important, but it is not enough. There can be no justice as long as justice is not given to the victims and to all the victims. There is no gainsaying that huge efforts have been made in the area of the provision, protection, and defense of the rights of victims. And I seize this opportunity to pay tribute to all the competent organs of the court that have made those efforts. I also acknowledge all the counsel, the teams in the fields, and who have been on a daily basis constituted the indispensable interface between the court and those who have suffered in their flesh and their souls the consequences of the most reprehensible crimes. The fact is that there is a lot of work still to be done that needs to take into account the complete and efficient interests of the victims. It is crucial for us to bear in mind that even if the legal sanctions, especially before your jurisdiction, in light of the retributive and deterrent effects of your decisions. And I will have to point out here that ever since the inception of the court, there are certain things that are no longer happening on our continent. However, the fact remains that the crimes that we are concerned with today have already been perpetrated, and there is no longer anything we can do about it. And as the Anglophones say, what is done is done. The crucial question that remains to be resolved, of course, after a conviction, will be the fair management of the unspeakable and immeasurable consequences that these atrocities caused and continue to cause on the victims. In order to be convinced and to take a very close look at the aspects related to this case, we have to visit the refugee camps like those in Chad, which we know. We are absolutely convinced that given the physical and mental distress, anxiety, stress, permanent desolation, and all the rest, it is still possible to do something. And this is the very difficult task that we are called upon to do. The idea that is underlying this commitment and which reassures us is that, to begin with, the provisions of Article 68(3) of the statute stipulate, and I quote here, Mr. President, as follows: where the personal interests of the victims are affected, the court shall permit their views and concerns to be presented and considered at stages of the proceedings determined to be appropriate by the court, and in a manner which is not prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial. Such views and concerns may be presented by the legal representatives of the victims where the court considers it appropriate in accordance with the rules of procedure and evidence. End of quote. Also, when you look at this text, to me it is a type of a puzzle because it is extremely complex. It is an article which is not easy to interpret, but we have to make do with it because it is the legal framework within which we must work. The second idea that reassures us is part of Rule 85A of the Rules of Procedure and Evidence, which stipulates that victims means natural persons who have suffered harm as a result of the commission of any crime within the jurisdiction of the court. These two texts would lead us to understand that victims, whatever their category, have a general right to access the proceedings, but as it has already been mentioned before, only a very minor portion of those victims were authorized to participate, and most of them are people who are still living in the CAR. So these are the residual numbers of people who were able to escape the extermination, as well as a few people who went into exile and then voluntarily accepted to return home. I'm insisting focusing on this word home, because most of the people that we have met consider the Central African Republic as their motherland. Out of the other thousands, tens of thousands of those exiled in Cameroon, the Democratic Republic of Congo, Congo-Brazzaville, Chad, Senegal, Mali, and others, only a handful were admitted to the proceedings. But the question that we must ask is, where are those dozens of thousands of refugees repatriated by entire convoys that we saw on world television stations? We can legitimately ask this question because it is paradoxical. It appears very clearly that most of those who suffered these atrocities as a result of the vicissitudes and intricacies of legal proceedings are today absent because of the fact that they are not considered to belong to the category of people affected by the case. And so their fate is largely dependent on the various interpretations and understandings based on the various levels of decision making. In addition to the defense and the prosecution, they are full parties, but legal representatives are only participants, and not even automatically, because their participation is very limited. Given the generality of the language, Article 68.3 is very elastic and opens the door to broad-based interpretations and assessments which may introduce uncertainty and unfairness in the treatment of victims. And yet, Your Honors, the fundamental place occupied by the victims in the system of the court is one of the best guaranteed criteria and unquestionable attributes of the court's legitimacy. The essence of your institution and the raison d'etre of the court, which we refer to as its causa prima, is of course the fight against impunity, but especially the victims. What is certain is that as far as the diaspora is concerned, their state of victimhood as defined in Rule 85 of the RPE is intangible. They are at least victims of forcible deportation. And yet we have the impression that so far the discussions that followed the Rome and Kampala conferences, as well as the comments made on the various decisions handed down by the international jurisdictions relative to the notions of victims and the situation of the victims in all those cases have not lost their urgency. Obviously, it is absolutely necessary to refrain from a utilitarian vision of the notion of victim, that is, a victim who is merely there to be used as a witness by the prosecutor to prove his or her case and by the defense to exculpate their clients. They have to resolutely engage in the humanitarian aspect. During our various missions that we carried out, we realized that the victims were in an untenable situation, because after the agony and exactions suffered in the CAR, they are also suffering the agony of the complexity of the proceedings. As far as those of us counsel are concerned, it is very difficult to come face to face and explain this situation, the legal situation, to the victims. Quite frequently, we were completely helpless in the face of the relevant questions put to us. How can you make someone understand? That is someone who, because of the situation, was plundered, brutalized, and sometimes raped. And today, they are confined for several years in refugee camps. And how can you explain to those people that they are excluded from the proceedings? It is not easy. And this is a situation that cannot be set apart from the victim's participation, because simply the forms that they filled were inaccurately filled and fraught with errors and incoherence. Those were rejected. Can one expect coherence and a good memory from these people who, for the most part, lost their faculties, including their reason? We met people who were mentally handicapped, people who, because of the events, became like fools. I'm sorry for using that word. Despite all the efforts made and all the progress made, both in the area of legal instruments and jurisprudence, one must admit that the place of victims in the proceedings continues to be problematic and borders on the enigmatic. The mandate that we have received from the court is centered on the representation of the interests of the victims that have been authorized to participate. But if, in addition to the instruments or texts that have been mentioned, we refer to the decision of Pre-Trial Chamber 2, we can understand that we may take care of anyone who is a victim. And these people have missed no opportunity to tell us about their concerns. Despite our commitment and the relentless support of the case managers, other field officers, and intermediaries, we can reassure you that there is still a lot of work to be done. And I'm talking specifically on the applications for participation filled by the intermediaries. Many of them were rejected because of incomplete and incorrect information. The task is very difficult and almost insurmountable. With these people who have lost all their reference points, we have found a situation unimaginable. So how can one rectify such situations, especially given that the refugee cards are the only identification documents in the possession of these victims, who rely on other victims to tell people what has happened? And to conclude, I will talk about the structure and the function of legal representation, which constitutes a window through which the jurisdiction sees the victims. Within this framework, we have the impression that we are in the presence of a representation within a representation. What was decided is that each council counsel should be present in the hearing for a period of 1 month and on a rotational basis, representing the entire team and on behalf of all the victims. When it came to practice, this became very difficult. It is true that before our appointment, we all accepted to work within the same team in perfect symbiosis and in perfect collaboration, representing all the victims, notwithstanding their place of residence. But the reality in the field, which has been compounded by the health pandemics, despite our efforts, this has led to a difficulty that is difficult to overcome. And as I said, we have tried everything and it is difficult. And to conclude, Mr. President, Your Honors, I would like to say the following. Justice is, of course, very powerful because it is the justice system that determines the mandate and hands down convictions, but it should not use its power only in that area. It has to be credible. That is, it has to be understood and accepted by the justice or the people to whom justice is rendered. So we must not lose sight of the fact that all victims, including those who are present and those who are not present, should be alert. We know that they are alert and listening to everything that is happening and will happen here. They should be able to say justice has been done. This is a heartfelt appeal, and this is something we have heard throughout all the missions that we have carried out, and more than everything else, this constitutes the core concerns of the victims that we have met with. Thank you very much for your kind attention.
Thank you very much, Ms. Masida.
Your Honor, Ms. Rabesandatana will conclude the opening remark for the team. Thank you.
Monsieur le Président, Messieurs les juges,
Your Honours,
en tant que représentants légaux,
as legal representatives of the victims,
en tant que représentants légaux des victimes,
as legal
nous
representatives of
sommes
the
la troisième
victims,
voix,
we are the third
la
voice,
voix dont vous avez eu la démonstration
the
par les
voice
explications
which
de
is you
vos
have heard
confrères,
this
la
morning,
voix du
listening
terrain.
to my learned
Nous
friends,
sommes la troisième voix, la voix de
the
ceux
voice that
qui
expresses
sont opprimés,
the reality in the field.
ceux qui subissent
We are the
en
voice of those
silence,
who are oppressed,
Ceux
those
qui
who suffer in
survivent
silence,
dans un contexte
those who
politique
survive
fort
in a
et
political
violent
context
qui dépasse chacun
which
chacune
is
d'entre eux
violent and beyond the
et
control
d'entre nous.
of any one of us.
Il faut que notre voix soit activement
It is important that
associée
our
au
voice
processus de
is
justice
actively
et qu'elle
incorporated
trouve dans ce
into the
procès
judicial
qui va
process,
s'ouvrir sa
and that it
place
is heard
et son sens.
in the trial which is about to open,
Permettez-moi,
that it have
Monsieur le Président,
a place
Messieurs
there
les juges,
and that
d'ouvrir
it be
cette
heard.
problématique de la
Your Honours,
défense
allow
des
me to
victimes
address the
et de poser la
issue
question
of
essentielle.
defending victims
Quelle
and to put the key
ambition de
question,
justice
and that is,
pour les victimes
what
devant la
is the
Cour
International
pénale
Criminal Court's
internationale?
ambition for victims?
L'on se souvient des propos du président
We
Philippe
recall
Kirch,
the words of President
responsable des
Philippe
négociations
Kirch,
diplomatiques
who led the diplomatic
statut de la Cour
negotiations
et premier
on
président
the
de celle-ci.
statute of the International Criminal
À
Court
propos de la
and the
condition
first
des victimes,
president of our court.
il disait une ambiguïté
Regarding the
constructive.
condition of victims before the court,
La
he said,
situation
and
des
I quote,
victimes
it is a case of constructive
Cour
ambiguity.
reste un paradoxe.
The situation of
Car, à
victims
défaut
before the International
d'être au
Criminal
centre
Court is
de l'enquête
paradoxical.
et du jugement,
They
sont placées dans
are
une
not
périphérie,
at the center of
dans la pénombre d'une
investigations and the
relation
trial,
surexposée,
but rather they find
celle de
themselves
l'accusation
on the periphery,
et celle de la défense,
overshadowed
autour
by
des figures
one
des
relationship
accusés.
which is in the
Pour
spotlight.
souligner cette
That is to
place
say, the relationship between the
désavantageuse,
prosecution and the
l'expression de
defense
victimisation secondaire
in
est
connection
utilisée.
with the accused.
Je vous renvoie à
This
ce propos
position
l'allocution
of the victims
de
is
notre
somewhat
confrère
disadvantageous
Yarefal,
and,
qui a expliqué
in fact, is a type of secondary
que
victimization.
représente pour
Now,
les
I would
victimes
refer
le fait
to
de
the opening statement by my
à la procédure,
my colleague Yarefal, who explained the calvary that victims must go through in order to be able to participate in these proceedings, filling out forms, encountering practical and psychological difficulties of various types to do that, and having to overcome a number of
Vous aurez
obstacles
aussi entendu
simply
les descriptions
to arrive at the point
Maître
where they can
Dangabo,
file a
ça,
request to
concernant les
participate.
victimes de la
You've
RCA
also heard
vivant dans les
descriptions
enclaves,
given this morning
tremblant
by
pour leur sécurité.
my colleague
Maître
Dangabo
Douzima vous adressait
Moussa
un état de la
regarding
situation politique actuelle
victims
et comment est traitée la
in the
population
Central African
civile
Republic who found
qui n'en peut
themselves in
plus
enclaves
de ce lutte de
and
pouvoir,
fear for
et pourquoi
their
elle
security.
regrette la
Ms.
restriction
Douzima
du champ
also
territorial.
sketched for you the current political situation and the way in which the civilian population are treated against a backdrop of political
Pour autant,
or struggle, a
parce qu'il
political
fait
struggle for
état des
power,
victimes,
and why
le
she
statut de Rome
is
est loin
she
sur ce
regrets
point des
so
initiatives
that the
de
territorial
ses
scope
prédécesseurs en
for
matière
participation
de
of victims
justice
has
pénale
been so
internationale.
limited.
Car ni le
As
tribunal
she
militaire de
intimated,
Nuremberg,
a disastrous signal is
les
being sent
juridictions pénales
to the supporters of
ad hoc
Mrs. Messrs.
ou
Ngaïssona
Rwanda
and
n'ont
Yekatom.
fait place aux victimes.
Yes, indeed, we can talk about
Ce qui
secondary
ampute
victimization
le
right at the
processus
outset of this trial.
De la justice pénale internationale,
That said,
de la cause
the International Criminal Court and the Statute of Rome is somewhat more advanced when it comes to the role accorded to
La logique
victims
causale
than international
disparaissait
criminal justice
au
hitherto.
profit d'une
Neither the
analyse
International Military
strictement
Tribunal
conséquentialiste.
or at
Grâce à la
Nuremberg,
Cour
nor the ad hoc
Et
criminal
merci du
courts
statut
for
de Rome,
Yugoslavia and
cette logique
Rwanda
ne se retrouve pas
accommodated the
dans la
victims
pratique de la Cour.
in the way which they are accommodated at the
Pour autant,
court. They focus
les
rather
victimes
more on the
restent
cause
à la
and not so
périphérie
much on the
du procès.
consequence, or rather there is a dislocation
La question
between
que la
their
Cour
examination of
doit
the
se poser
cause of the
et
crimes
que nous posons,
and a
nous,
concentration on the
représentants
consequences of the
légaux
crimes.
communs des victimes,
When
celle
the causal link
de faire
disappears in this
avancer
way,
la
one
cause des
ends up
victimes.
with a very
C'est tout
consequence-focused approach.
Et c'est notre devoir.
Thanks to the International Criminal
Qu'attend-on
Court and
de
the
la
Rome
justice
Statute,
Cette
that
affaire
is no longer the thinking or the
permet-elle
practice
pas,
of the court.
en tenant compte
Nonetheless, the
des
victims do find
précédents
themselves
dont la
on the
Cour a fait
sidelines
preuve,
of such a trial.
d'aller plus loin encore
The question that the
afin
court
de
and we,
donner
as legal
aux
victims,
dispositions
legal
du
representatives
statut
of victims, need to
une
put to
meilleure
ourselves
place
is
pour les victimes.
what is one to expect from criminal
Car oui,
justice.
la Cour se doit d'être un exemple
This
pour
case
l'ensemble des juridictions et du droit
has the means to
international.
carve out a
Il
better
nous semble
position
qu'elle
for
doit
victims.
Formuler
The
principes généraux
ICC
de droit commun
must serve as an example to
différents
all
ordres
courts and to
et
international law in general.
susceptible de guider l'interprétation
It seems to
adonnée
us that it
aux
is important that general
différentes disciplines du droit.
principles,
Elle
general
doit
legal
contribuer
principles which are
à
common to
former
all
des interactions
legal
entre le
orders
droit
are
international et
derived,
le droit interne
which
et
can
construire
guide
ainsi
the
l'unité
interpretation
du droit.
of the various disciplines of law as
Elle doit
regards participation
favoriser
of
la
victims.
primauté du droit sur
The
la
court
force
also needs to contribute to
corruption
interactions between
la lutte
international law
contre
and domestic
l'impunité.
law and
Et elle
bring
doit-
about a unicity of law.
C'est un idéal.
It also needs
Mais
to
sans
support the primacy of law
n'avançons
over
pas.
force
Elle doit
and
permettre
corruption,
à un
and
pays de se
it must
reconstruire.
also favor the struggle
souhaitons et
against
nous disons que la
impunity.
justice
It must allow a
internationale
country
positive
to reconstruct
peut pas,
itself, to
ne
rebuild.
doit pas contribuer à fragmenter le droit.
We wish to
L'unité
see
du droit
positive international
consiste
justice,
à
which does
octroyer
not cause
place
law to further
adéquate
fragment.
aux victimes
Unicity
Et
of
ainsi,
law is
de passer
involves
d'une relation
granting
duale,
a sufficient position
binaire,
to victims,
accusation
and to move away from this binary relationship, prosecution-defense, and to move towards a triangular relationship, prosecution, victims, defense. The court must not contribute to fragmentation because winning the peace is more complicated than winning the war. This noble and ambitious responsibility which the statute of the court captures in its preamble, where it alludes to present and future generations as being an essential condition for a durable peace, is one that we need to embody. The legal representatives for victims must do so, and we must contribute to bringing about a long-term peace, stability, and fair development for this country which is emerging from crisis. So let's have a look at the statute and specifically what it says about this third voice which we represent. First of all, we note the poverty, if you like, of the exegetical approach to the statute, reading it in isolation. Now, my colleague read the article to you, that is to say Article 68, and it really merits our attention. So, Article 68, paragraph 3 states that where the personal interests of the victims are affected, the court shall permit their views and concerns to be presented and considered at stages of the proceedings determined to be appropriate by the court, and in a manner which is not prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial, etc., etc. So here the statute accords a status to the victims and their right to express their views and opinions, provided that they have a personal interest, that their personal interests have been affected. Now, that is a particularly restrictive clause because the concept of personal interests of the victims being affected is one which can be interpreted in various ways in a more or less limitative fashion by different chambers and judges. Now, thankfully for us, there is Article 75, reparations for victims, which makes it crystal clear that the victims are participate fully in the trial and that they have fully fledged rights. Now, that article, important as it is, comes into play at the very end of the proceedings, after a judgment has been arrived at and after a sentence has been delivered. It is not relevant to us today. If you like, it pulls back, draws back something for the victims and the principles. But one cannot say that its application has been a real success for victims hitherto, given that since 2005 only 2 reparations orders have been issued in the case of Al-Mahdi and Katanga. So, you might say, what to do? Well, our first proposal is not to limit oneself to an exegetical reading of the statute. Rather, the statute must be interpreted in the light of international law. In other words, based on a teleological approach. An exegetical reading is not in line with any of the canons of interpretation of in the international law of treaties. Now, there are 2 courses here. You have the Vienna Convention and the texts of the United Nations. As regards the Vienna Convention on treaty law of the 23rd of May 1969, its Article 31, paragraph 1, states that A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. Object and purpose. The object and purpose here is that justice be done, full justice, not partial justice. For instance, only punishing but without fully taking account of the victims, or only awarding reparations without dealing with those accused of the crimes. These two things are two parts of bringing about justice: punishing and affording reparation. And they place the victim at the heart of the trial and not on its periphery. This is important. Now, Article 31, paragraph 3 of the Vienna Convention on Treaty Law is also important. It says that there shall be taken into account, together with the context, any relevant rules of international law applicable in the relations between the parties. Now, Article 31 of the Vienna Convention on Treaty Law is fundamental when it comes to the position of the legal representatives for victims. And that is the provision to victims of their true place in legal proceedings. Now, what does that mean? It means interpreting the statute in the light of international law. The International Criminal Court can no longer ignore Article 31, paragraph 3c of the Vienna Convention, nor can it ignore the steps taken by the United Nations to give access to victims to justice at the domestic and the international level. And here I would take you to the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, adopted by the General Assembly as Resolution 40/34 of the 29th of November 1985, which defines the concept of victim in a very full and rounded way. So, it states, firstly, that victims means persons who, individually or collectively, have suffered harm, including physical or mental injury, emotional suffering, economic loss or substantial impairment of their fundamental rights, through acts or omissions that are in violation of criminal laws operative within member states, including those laws prescribing criminal abuse of power. And that declaration goes on to further define victims by stating that a person may be considered a victim under this declaration regardless of whether the perpetrator is identified, apprehended, prosecuted or convicted, and regardless of the familial relationship between the perpetrator and the victim. The term victim also includes, where appropriate, the immediate family or dependents of the direct victim, and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. And then it is further specified that the provisions contained herein shall be applicable to all, without distinction of any kind, such as race, colour, sex, age, language, religion, nationality, political or other opinion, cultural beliefs or practices, property, birth or family status, ethnic or social origin, and disability. Finally, and this is the most important thing, the declaration states that victims should be treated with compassion and respect for their dignity. And it states they are entitled to access to the mechanisms of justice and to prompt redress. Prompt redress. So those are the UN texts. The statute of the ICC is lower than these requirements, And the reasons put forward for limiting the position of the victims are based on an isolationist vision of the statute. This pro-victus position, which takes into account all of international law and our current epoch, is one which is shared by the independent expert Diana Ornlicher, who is an independent expert responsible for updating the set of principles to combat impunity. And I quote, "Although the decision to prosecute lies primarily within the competence of the state, victims, their families and heirs should be able to institute proceedings on either an individual or a collective basis, particularly as partie civile or as persons conducting private prosecutions in states whose law of criminal procedure recognize these procedures. States should guarantee broad legal standing in the judicial process to any wronged party and to any person or non-governmental organization having a legitimate interest therein." When a state is not capable of providing access to the law, the court must step in. Whence, of course, the need to further bolster the standing of victims in international trials. Allow me, during these opening statements, to give some food for thought, some avenues to be considered. The status of victims at this court is both impressive but also rather partial, a little patchy. There are differences between the chambers. There are tensions. The question which I put to myself is why do international criminal proceedings place victims in a corner, in an outlying location in the trial framework? And I'd like to provide two explanations for that, which strike me as particularly important. First of all, the victims represent the field. Suffering, abuses, and their views being expressed at trial render the psychological forces at play rather complex, terribly complex, bringing in this emotive contribution. Secondly, the victims threaten the dual relationship between the prosecution and the defense. So how can one associate the victims in the legal process? Proceedings at the court require a finding beyond reasonable doubt. And this leads to legal paradoxes. Let us remember paragraph 36 of the obiter dictum of the court's judgment of the 18th of December 2012, acquitting Matthew Ngajolo. And I quote, "Finding an accused person not guilty does not necessarily mean that the chamber considers him or her to be innocent. Such a finding merely demonstrates that the evidence presented in support of the accused's guilt has not satisfied the chamber beyond reasonable doubt." To find somebody guilty, that finding must be based on evidence. Evidence which must be weighed and reweighed by the prosecution and by the defense. That said, it is damaging when justice is not done, as the judgment, the Ngajolo judgment, indicates. As you know, the threshold to be met for you is beyond reasonable doubt and not intime conviction, or that judges be thoroughly satisfied of guilt, as is the case in some criminal jurisdictions. That latter threshold is sometimes said to be excessively subjective. Here, the system of beyond reasonable doubt is applied, involving victims in the judicial process allows them to contribute to uncovering the truth and to establishing it beyond any reasonable doubt, whether that leads to acquittal or to conviction. It is not acceptable, we believe, that in the interests of the so-called equality of arms, that truth escape us due to the victims not being involved as they should. The victims are present in the field. They have lived through the events and the crimes that have taken place. Why leave them on the sidelines? What we have to say is not the same as what the prosecution has to say. What we say in an autonomous fashion to inform the chamber and to speak to the causes. Understanding barbarity allows one to explain it. The role played by the victims is not unconditional. It takes place under the supervision of the judges. We, the legal representatives for victims, play a dual role. We are the advocates of the victims, but we are also mediators between the judges, between them and the judges, the prosecution and the defense. We, the legal representatives of victims, based on legal reasoning and the science of the law, and through our abilities and what we bring in terms of the intelligence of our minds and the compassion of our hearts, contributes to overall justice, achieving the overall justice expected by the victims. We listen to what they have to say, we find agreements, we work with our partners in the defense and in the prosecution, trying to seek out the truth and to have it expressed and recognized. This legal truth is something that the victims need. It's not a matter of the victims simply spilling out their grief and sorrow, as one might see in the case of a Justice and Truth Commission, but rather involving the victims in obtaining justice, a justice which is comprehensive and inclusive, and will help to assuage their inner demons, will help them to rebuild their lives individually and collectively. One does not happen without the other. They need justice to be done, and they need the truth to be stated. A nation, a people, cannot be built on a vacuum, on a holes, something which is not a firm foundation. It cannot be built on lies or on denying history. In achieving justice and truth, the victims cannot choose between one and the other, justice or truth. Rather, simply transplanting them in their home country, the country of their birth, is impossible. The verdict which will emerge at the end of these proceedings will allow them to feel better understood and better accepted, and it will allow them to enjoy and live through their collective and individual resilience. Peace is learned, it has to be discussed, it has to be built. Thank you for having heard me out.
Thank you. I think, Ms. Masida, this concludes the presentation by the victims' representatives.
Yes, Your Honor. This concludes the presentation by the common legal representative, both teams. Thank you very much.
Thank you. And this also concludes the hearing for today, because we have assured the defense of Mr. Ngaïssona that they can start on Thursday, and we will do that tomorrow morning at 9:30.
All rise.